Right. So this is the matter of the Queen against Andre Bryan and others who are charged with an indictment, a multiple count indictment with various offenses under the Criminal Justice Suppression of Criminal Organizations Act, as well as one defendant being charged with offenses under the Firearms Act. Because it is a criminal trial, there are certain fundamental principles that apply in all criminal trials. These principles are constant, and for the most part, they never change. The first of these fundamental principles is that the burden of proof is on the prosecution, and it never shifts. And none of the circumstances in law where the defendant may have an evidential burden apply in this case. The second fundamental principle is that the case must be proved to the requisite legal standard, which is proof beyond a reasonable doubt. A necessary conclusion from this is that any reasonable doubt that arises on the ultimate issue of guilt must be resolved in favor of the defendant. The third fundamental principle is that the prosecution must prove the guilt of the defendant in respect of the offense charged. It follows that if the commission of a crime generally has been established, but it is not the crime charged, and the crime proved is not an included offense within the particular count, then the defendant must be acquitted. The fourth fundamental principle is that the prosecution must prove each element of the offense charged. The fifth fundamental principle is that the defendant has no legal duty to prove his or her innocence. So a criminal trial is always about whether the prosecution have proved the case and not whether the defendant has proven his or her innocence. The sixth fundamental principle that flows out of the previous ones is that the prosecution must prove the defendant is guilty of each crime with which he or she is charged, and therefore, guilty or not guilty on one charge does not ordain or indicate that the defendant is guilty or not guilty on another charge. Put another way, each count is to be considered separately. The seventh fundamental principle is that there is not to be any prejudice for or against any of the defendants or their witnesses or witnesses for the Crown. And the eighth fundamental principle is that all relevant material is to be assessed against the applicable legal standard, and then inference and findings of fact are made. Now, there are other principles of law that arise in the specific context of this case. And the first is that the two main witnesses for the prosecution are accomplices, or if not accomplices, but certainly witnesses with interest to serve. Both of these witnesses have made the claim that they are part of a criminal organization, and from the evidence that they have given, they were active participants in a number of activities that they claim were committed by themselves and by members of the criminal organization. By their own words, they have indicated that they were parties to murders, conspiracies to murder, and other criminal offenses. The first witness who testified in terms of the chronological order of witnesses was in fact charged under the Criminal Justice Suppression of Criminal Organizations Act. As it presently stands, he's no longer charged, as far as the court is aware, with any criminal offense. And there is no evidence that he pleaded guilty to or intends to plead guilty to any criminal offense arising in this or any other case. And so from that standpoint, he has every incentive to keep that situation as it is, that is to say, maintain his uncharged status. The second witness was not charged with any criminal offense, and certainly he too has every incentive to maintain his current status, that is, an uncharged person. As I indicated earlier, even if they are not accomplices, they have vested interest in escaping prosecution for criminal activity. In the circumstances of this case, it is highly desirable that there be corroboration of the testimony of the two main witnesses. And corroboration is simply relevant, admissible, and credible evidence from a source other than those two witnesses to show that the crime charged was committed and that it was a defendant or defendants who committed the crime. And one defendant, one accomplice, cannot corroborate another accomplice. In this particular case, another principle that has arisen for consideration and application in this case is the question of identification. This particular case has three types of identification. The first is visual identification, the second, voice identification, and the third, identification by way of DNA evidence. Every type of identification has principles of law applicable to it. In respect of visual identification, the law indicates whether it is a case of recognition or seeing a defendant for the first time when the crime is being committed, and where there is a challenge to the correctness of the identification or to the circumstances under which the identification is made, then the court must keep in mind certain things. For example, it has been said that an honest witness can be a mistaken witness, but be very convincing in his or her error because he or she is honest. The law has recognized that there have been wrongful convictions based on errors in identification. And an error in identification is still an error, whether it is deliberate error, as in a lie being told, or a genuine mistake. And so to guard against the risk of mistaken identification, the law has established an analytical guideline or analytical process derived from the practical experience of trials over many, many years. And so in essence, the law is saying then that identification evidence can be broken down into two dimensions. First dimension is that of prior knowledge, and the second one is identification at the time when it is being said that the crime alleged was committed. In respect of prior knowledge, the whole purpose of that is to address or minimize the risk of mistaken identification. And the logic of it is this: the greater familiarity that the witness has with the defendant, then the less likely it is that the witness is making a mistake. That is the essential logic behind it. But nonetheless, the law requires that the circumstances of the prior knowledge be examined. For example, the frequency of sightings, the time between last seeing the witness and seeing the witness at the time the incident was committed. And so that is part of the examination that must be undertaken to assess the strength, reliability, and accuracy of the identification evidence. So questions such as, had the witness ever seen the accused before? How often? If only occasionally? Had he any special reason for remembering the defendant? So those are the types of questions that you ask when looking at the question of prior knowledge. Of course, there may be cases where there is no evidence of prior knowledge. And in this particular case, the witnesses, the two main witnesses for the prosecution, are making the claim that they knew the defendants before for an extended period of time. Now, regarding seeing the defendant at the time the alleged crime was committed, again, there are questions that guide the analytical process. For example, how long did the witness have the accused under observation? At what distance? In what lighting? Was the observation impeded in any way? As, for example, passing traffic in a crowd? Was the defendant masked? Those are the kinds of questions that are asked to place the identification at the time of the incident under close scrutiny. And the answers to these questions must be found in the evidence. In this case, a number of identification parades were held. And the purpose of the identification parade is to test the witness's ability to identify the defendant using their own independent recollection, unaided, unprompted by any source external to themselves. So where the witness purports to identify the defendant on an identification parade, the court must examine the evidence to see whether the parade was conducted properly. The ultimate question is whether the witness's identification was independent, unprompted, and as I said before, unaided by any source other than his or her own independent act of recollection. The second type of identification engaged in this case is voice identification. Has similar principles and similar questions to those which guide the analytical process when looking at visual identification. Because again, what the witness is purporting to do is to say, I am familiar with the voice of the witness, of the defendant. I heard the voice in specified circumstances or in a number of circumstances before the critical time, which is the time at which the crime is supposed to have been committed. And so, similar to visual identification, the analytical process can be divided into two parts. One, prior knowledge of the voice, and secondly, sufficient opportunity to hear and recognize the voice on the day or dates in question in the particular offense. And as I indicated, the underlying logic is similar. The more familiar one is with the voice before the dates relevant to the commission of the offense, then the less likely it is that the witness is mistaken. But nonetheless, it is not unknown that errors are made and have been made in respect of voice identification, even in respect of persons who are well known to the witness. And so similarly, the court has to keep in mind that there have been wrongful convictions arising from mistaken voice identification, and an honest witness who is convinced that the voice that he or she heard at the material time is that of the defendant can still be mistaken. And because they are honest, they tend to be convincing. And so, in essence then, when one is dealing with voice identification or visual identification, the law distinguishes between honesty and reliability. So a witness can be honest but very unreliable based upon an objective assessment of the evidence. And so it is not just simply a question of whether the witness is honest, but also whether the testimony given by the witness is reliable. Of course, if the witness is found to be untruthful or unreliable, then that speaks for itself. So, regarding the prior knowledge of voice identification, the questions that one would ask are, where had the witness heard the voice on previous occasions? In what circumstances? How long had the witness heard the voice on the previous occasions? Did the defendant speak sufficiently long or frequently for the witness to have heard enough to determine that he or she knows the voice of the defendant? Did the defendant's voice have any distinctive features? And so those are the questions that one would ask when examining the prior knowledge or alleged prior knowledge of the voice of the defendant. When it comes to identifying the voice at the relevant time, the questions are, how long did the witness hear the defendant speak at that time? What were the conditions under which the defendant spoke? Was the time of speaking and hearing sufficiently long for the witness to make an identification of the voice on that occasion? So that is the second type of identification, in this case, which we'll examine in more detail as one reviews the evidence. The third type of identification in this case is that of DNA. DNA profiling involves comparing DNA from the questioned source and comparing it to some other sample that is from a known source. And so what is being looked for is similarities or dissimilarities between the known and the unknown. The characteristic of one section of DNA are not unique to that person because many other persons may share the same characteristics at the same specific sites. The number of sections of the DNA examined heavily influences the accuracy of DNA evidence. And so the logic seems to be that the more sections that are examined and analyzed, and the more the sections have in common with each other, the greater likelihood that the DNA of the unknown sample is from the source of the known sample. If there is a discrepancy between the known and unknown, then no link between the two can be established. Now, if there's a link between the two, it does not automatically follow that the unknown DNA is from or connected to the known DNA sample. The other evidence in the case will have to be examined. And after the analysis is completed, and if the link between the known and the unknown is established, then the next stage of the inquiry depends upon the statistical likelihood of an individual section or sections being found in some other source other than the source from which it is supposed to have come. In this context, the determination, well, in this particular case, the determination that is being sought is the likelihood of the male and female bodies found in a burnt building are the daughter and son of the mothers in question. So what we have here is not the usual type of case where you're talking about a sample of the defendant is taken that is being compared to some DNA found at the scene of the crime, where it is being said that the DNA at the scene of the crime is from the defendant. Here, what is being said by the prosecution is that there was a fire, two bodies were burnt, and the DNA from the two bodies was taken and compared to two DNA samples from two women who were said to be the mothers of the male and female, respectively. So that is the context in which the DNA identification has arisen in this particular case. The prosecution is saying also that markers were used to identify the specific DNA sequence. At the time of this examination, 13 DNA markers were used. In effect, the prosecution is saying that there were 13 specific DNA sequences in the bodies that match the specific DNA sequence in the mothers. So this, taken along with the other evidence, point to the bodies being that of the son and the daughter of the mothers, respectively. Now, a critical part of this aspect of the matter is the chain of custody from the scene where the burnt bodies were found to the funeral home, and samples from the bodies that were taken, that went to the forensic lab where the DNA analysis was carried out. So this chain of custody, along with the evidence indicating who the occupants of the house were likely to be, will have to be examined carefully. And I say likely to be because there was really no direct evidence that at the time of the fire, the persons who the prosecution are claiming were in the house were in the house. Because if I recall the evidence correctly, as far as the young lady or the female body is concerned, no one saw her enter the house, at least there's no evidence of that. And also, it does not appear from the evidence that she was a resident of the community. It appears that, well, let's put it this way, there's no evidence that she was a resident of the community. That is the person who the prosecution is alleging was burnt in the house. And as far as the male is concerned, what is being said by the prosecution is that that is where he lived, and they brought relatives to say, well, that is where he lived, but the actual evidence does not indicate that anyone actually saw him entering the house prior to the fire or anything like that. So, in effect, what the prosecution is asking the court to do is to draw an inference from the totality of the evidence that the male and female bodies found at the fire scene were the son and daughter of the mothers, respectively. So we'll see what we make of that at the end of the review of the evidence. Another aspect of this matter, so that concludes the three types of identification that have arisen in this particular case. In this case, the Crown has to prove the existence of a criminal organization. But I'll delay that aspect of it until I get further down. Yes. The principles relating to inconsistencies, omissions, and discrepancies will have to be utilized in this particular case. You have to keep in mind that the purpose or purposes of cross-examination are usually threefold. One, to obtain evidence favorable to the cross-examiner's case. Two, undermine or cast doubt on the accuracy of evidence given by the witness, or to impeach the witness's credibility. Many times, there's not much difference between 2 and 3, since undermining the witness's credibility may have the consequence of casting doubt on the accuracy of the witness's evidence. In the present case, the effort in the main during cross-examination of the witnesses, particularly the two main witnesses for the prosecution, was to impeach their credibility. And this the defense sought to do largely by establishing inconsistencies and omissions and discrepancies. An inconsistency arises when a witness is proven to have said something on a previous occasion that is different or contrary to what he or she is saying in court. So in this particular case, the defense endeavored to establish that in the witness statements given by the witnesses, they were saying things on critical areas that were not just different, but contrary to the testimony that they were giving in court. And so what the law says is that where there are inconsistencies or multiple inconsistencies, particularly on critical issues, it may have the result of destroying the witness's credibility completely or on that particular issue. But that determination will have to be made in the context of an examination of all the evidence in the case. And the court will have to take into account as well any explanation given, if any, by the witness, and whether that explanation is plausible or reasonable. So that is how the court deals with inconsistencies. In respect of omissions, what the defense are saying is that in this particular case, the witness or two main witnesses have omitted critical information from their witness statements, and they have sought to give that evidence here in court when they are giving evidence on oath. And so the defense is suggesting now that where you have these omissions on these critical issues, then that is an indicator that the witness is either lying or unreliable, or at the very least, grave doubts ought to be entertained about the witness's overall credibility and reliability. And so, similar to inconsistencies, one looks at the nature of the omission. Is it a significant omission? Is there an explanation given by the witness? And at the end of that analysis, along with all the evidence, examining all the evidence in the case, a determination is then made as to whether the omission leads to the conclusion that the witness is unreliable or not to be believed on that particular point, or not to be believed generally. And of course, the defense is saying, in this case, having regard to the inconsistencies as well as the omissions, not only the frequency and the number, but the nature and quality of the omissions and inconsistencies, these two main witnesses ought not to be believed on any critical issue in this case. And finally, we come to discrepancies. And discrepancy arises where there's a difference between two or more witnesses on a particular point. And again, where this occurs, the court has to look at the discrepancy between the witnesses, determine whether it is significant or not significant. Can it be safely be ignored? Is it on a critical point? What is, in effect, the analysis is to determine the effect of the discrepancy, the difference between the witnesses. And so what the defense is saying in this particular case is that when you take into account the nature and quality and number of inconsistencies, omissions, and the discrepancies, then overall the prosecution have failed to prove any of the charges preferred against the defendants. But of course, the court has to bear in mind that inconsistencies, omissions, and discrepancies are common occurrences in criminal trials, and their existence does not inevitably mean that the prosecution have failed, but rather indicates that the evidence must be examined carefully in the manner suggested already in order to determine whether the prosecution have discharged their legal burden, which is to prove the case beyond a reasonable doubt. The other principles that arise in this case are the good character. Some of the defendants have raised the issue of their good character, and they're relying on their good character as part of the totality of evidence in the case. Now, good character, certainly in the context in Jamaica, exists when the person has no known previous convictions, reprehensible behavior that is either admitted or proved. And in this case, a number of the defendants have made the point that they have no previous convictions and that they are hardworking, upstanding citizens of the land, looking after their family and going about their lawful activities. Right? Where the defendant has placed his good character before the court, it must be considered. Good character has two aspects to it. One, credibility, and two, propensity. Dealing with credibility first, it has been said that persons of good character are more likely to tell the truth about matters generally, and particularly in respect of serious matters of the kind which the court is now considering. So what that means is that the good character has to be taken into account in determining ultimately whether the prosecution have proved the case that they're alleging against the defendant. As far as propensity is concerned, what that means is that persons of good character are less likely to commit crimes or to engage in a life of criminality, especially serious crimes of the type with which the defendants are charged. Persons of good character are more likely to be law-abiding, truth-telling, upstanding citizens of the community, and they have no propensity for committing crimes. And so that is really the considerations that the court must have in mind when considering the character evidence that has been raised before the court. It must be borne in mind that good character in and of itself is not a defense to a criminal charge, but it is evidence that is taken into account and assessed as part of, as I said earlier, determining whether the prosecution have discharged their burden. And in this particular case, the good character assumes great significance because in respect of some matters, it is largely a credibility contest between the two, well, shall I say, gang members who testified for the crown and the defendants. So what we have is two persons who are, by their own words, self-confessed criminals, murderers, conspirators to murder, arms traffickers. I mean, they said these things by their own words, not I who am ascribing these things to them. As they have those persons who are lining up for the prosecution, and then as far as the defense is concerned, at this stage, there is no evidence that any of these defendants have any previous conviction for any offense, not even a parking ticket. So what the defense is saying then is that when the court looks at the good character of the defendants, it should tilt this case in favor of a not guilty verdict when the two witnesses for the prosecution have, well, they have said who they are, and you have the inconsistencies, omissions, and discrepancies. So that is the argument being advanced by the defense. Other principle that applies here is that when we are dealing with evidence coming in from the defense, because one of the inevitable consequences of the burden of proof being on the crown is that the defendant has no legal burden or duty to say anything, produce any evidence, or give evidence on oath. In this particular case, two defendants have remained silent. It is a right given to them by law, and no adverse inference can be drawn merely from the fact that they have chosen to remain silent. That's an option that is provided to them by the law, and they have chosen to exercise that option, so they can't be penalized for exercising an option given to them by the law. Some defendants, at least two defendants, give sworn testimony, and what the law is saying is that serious consideration must be given to the sworn testimony of the defendant. It is not to be discounted merely because it comes from the defendant. There's nothing to say, oh, sworn testimony from the defendant. Well, what else do you expect him to say other than denying the prosecution case and it be discounted or given less value because it is coming from a defendant? The law requires that it be taken seriously and assessed with the same degree of seriousness. And so a reminder then that when the defendant gives sworn evidence, it is an option given to him by law, and it is not because there is any legal obligation to give evidence on oath. And other defendants in this case have elected to make an unsworn statement. Again, it is the third option presented to them by the law, and it is not to be held against them. What the law says, however, in relation to unsworn statements is that the court is to give it such weight as I think it deserves. Now, in an unsworn statement, the defendant can raise issues for the court's consideration. And so the fact that he or she may have raised issues in the unsworn statement doesn't mean that it is considered in an inferior way. It is still to be taken seriously and taken into account in determining whether or not the prosecution have proved the case. Now, whether the defendant has remained silent or given sworn testimony or made an unsworn statement, we still need to keep in mind that because the burden of proof is on the prosecution, it necessarily follows that even if the defendant is disbelieved by the court, or his unsworn statement is rejected, or his sworn testimony is rejected, the rejection of the unsworn statement or sworn testimony does not automatically convert into a finding that the prosecution have proved the case, because it can simply be the case that what you have is liars all around, lying defendants, lying prosecution witnesses, and if the court concludes that all of these persons are liars, or, if you wish to be more polite, extremely unreliable, then what that would mean is that the prosecution would have failed. So a rejection of the defense does not inevitably and automatically mean that the prosecution have proved the case. It emphasizes the point that the case for the prosecution must still be examined to see whether the offenses charged have been proved by reliable and credible evidence up to the requisite standard of beyond a reasonable doubt. And the same applies in respect of the two defendants who elected to remain silent. So no adverse inference can be drawn because they remain silent. It is simply emphasizing that they are saying to the prosecution, you have brought me here. I don't think you have proved the case. I have nothing to say in response. And so the court still has to examine the evidence to see whether the requisite standard has been met in respect of those two defendants. The other principle that has arisen in this case is one of malice, because what at least one of the defendants is saying is that witness number 2 is highly motivated to tell lies on him because of jealousy in respect of a female. It is the argument, as I understood it, was that the female was supposed to be pregnant and the alleged father or person responsible for the pregnancy was not the witness number 2, and this took place at a time when witness number 2 was in an intimate relationship with the young lady in question. And so when apparently questions were being raised as to the paternity of the child, the defendant is saying, that particular defendant is suggesting that witness number 2 was now using this case as his opportunity to, I suppose, exact some revenge on him, assuming, of course, that he's the father of the child, or at the very least believed by witness number 2 to be the father of the child. And so the court has to be mindful that this allegation has been made and to look to see whether there's any substance to it. So those are generally speaking, the principles applicable in this particular case. Now, reference was made earlier and repeatedly to the point that the prosecution must prove the elements of the offense charged against the defendant to the requisite standard. So in this case, there are 5 offenses that have been included in the indictment. 2 are possession-based offenses: illegal possession of firearm, illegal possession of ammunition, leadership of a criminal organization, membership of a criminal organization, and facilitating serious offense by a criminal organization. So before getting into the legal ingredients of these charges, I must deal with something here now, and it is this. We are now in 2023, and this trial commenced in September of 2021. Since September of last year, there is a new statute governing possession, use of firearms. So that statute became law during this trial. Now, Section 27 of the Interpretation Act, as well as decisions from the Court of Appeal of Jamaica, and the Privy Council have made it very clear that this trial has to proceed on the, not that there were appeals on that aspect from this trial, but that this trial has to proceed as if the repealed Firearms Act was still in force. So the offenses of illegal possession of firearm and illegal possession of ammunition that are charged in this case will be analyzed in the context of the repealed statute and not the current statute. Why? Because Section 27 indicates that even where you have a repeal statute and the circumstances that gave rise to the charge arose before the statute was repealed, the adjudication proceeds on the basis that the repeal statute is still in force. So that is why we'll be doing that. Also, in respect of the indictment when the trial commenced referred to facilitating applicable offenses. That was a new expression introduced to the law by an amendment in 2021. The charges in this case allege incidents that are said to have occurred before the amendment. And so again, similar reasoning as to what I said earlier in respect of the Firearms Act would apply here. So the adjudication will proceed under the statute, that is the Criminal Justice Suppression of Criminal Organizations Act, as it stood before the amendment of 2021. So none of the amendments in 2021 of the Criminal Justice Suppression of Criminal Organizations Act apply to this particular case. So, that said, what it is that the prosecution needs to prove in respect of illegal possession of firearm, illegal possession of ammunition. Well, at the very least, they have to prove that the object in question is a firearm within the meaning of the Firearms Act that is now repealed, and that essentially is a lethal barrel weapon capable of discharging deadly missiles. And in respect of ammunition, it has to prove that it is ammunition within the meaning of the Repeal Firearms Act. Now, yes. In respect of the possession offenses, that is illegal possession of firearm and illegal possession of ammunition, the Crown must prove that the objects in question were under the physical custody or control of the defendant. And the Crown must also prove that the defendant knew that what he had under his possession or under his custody or control was a firearm and also ammunition. And proof of this will depend upon all the circumstances of the case and on the evidence and any inferences that can be drawn from any evidence that is accepted by the court to be true, accurate, and reliable. The On the question of knowledge, the court will have to look at the totality of the circumstances, always remembering that the burden of proof is on the Crown. And the Crown does this in determining what inference or inferences should be drawn. The court has to keep in mind that there'll be infinite variations in the circumstances of different cases, and so it will be for a careful examination of the facts and circumstances to determine whether the accused had the requisite knowledge. In this particular case, the prosecution is suggesting that police went to a home and a key that was produced by the defendant opened the door to a furniture shop. And inside that shop, among pieces of wood, a firearm was found. The Crown is also saying that there was no other place to enter or exit this shop. And so from all the circumstances, the Crown is relying on what is called constructive possession, that is possession of the key, and the key opened the furniture shop and the firearm and the ammunition in the shop to say that that particular defendant was in possession of the firearm and the ammunition. In response to that, the defense is saying no, the furniture shop in question has other points of entry, and so much so that persons are inferentially from what the defendant was saying and his witness trekking through the shop. So it wasn't a case in which the defendant had exclusive control over the points of entry and exit. And so in those circumstances, the defendant is saying, well, who knows? Any one of the persons going through the shop may have placed it there. And so the defendant is saying, well, I am not guilty of illegal possession of firearm because, one, I did not possess it. The exclusive possession of the keys that the prosecution is trying to place in me just simply doesn't exist. And in any event, the shop is open, door open, window open, all sorts of persons were trekking through this place, and they may have been the ones who placed it there. He's raising that as a possibility. He's not saying that that is definitely the case, but he's saying, well, those things can happen. So that is how the evidence unfolded there. So at the end of the day, when the court looks at the evidence in its totality, a determination will be made as to whether or not the prosecution have proved the illegal possession of firearm and illegal possession of ammunition charges to the requisite standard. Now, in respect of the facilitation offenses, and I'll just use one as a general example for the point that I wish to make. Essentially, they start out by indicating the name of the offense, facilitating serious offense by a criminal organization, contrary to the relevant provision of the statute. And then it states particulars that named defendants on a date unknown between date one and day two in the parish of St. Catherine knowingly facilitated the commission of a serious offense by a criminal organization, and then it goes on to either say it is either murder or conspiracy to murder, or in the case of one count, arson. And that is essentially how the facilitation offenses have been framed by the prosecution. So in breaking down now what the Crown must prove, start with the easiest thing first. The prosecution must prove that the facilitation occurred in respect of a serious offense. And the expression serious offense is defined in the statute, and it says that serious offense means an offense specified in the first schedule. So it does not mean serious offense in terms of the layman's understanding of, oh, this is a serious crime, or this is a serious offense, but it has a specific meaning in the context of this statute. So it must be listed in the first schedule. And as I indicated, the serious offenses listed in the facilitation counts in this indictment are conspiracy to murder, murder, and arson of a dwelling house. All three offenses, conspiracy to murder, murder, arson of a dwelling house, are listed in the first schedule of the statute. And as I indicated, we are looking at the statute as it stood before the amendments of 2021. One of the features of the 2021 amendment is to have an expanded list of serious offenses, and the label has changed from serious offense to applicable offense. So that doesn't arise in this particular case. Now, in criminal trials, careful attention has to be paid to the terms of the indictment, because when the defendant is pleaded, he's responding to the crime as it is framed in the indictment. And so that is what the prosecution now comes to court to seek to establish to the requisite standard. So, to use as an example again, when it speaks to knowingly facilitated, note the tense, the commission of a serious offense by a criminal organization, and then it goes on to name the serious offense, whether it is conspiracy to murder, whether it is murder or arson. The prosecution is saying that those serious offenses in fact occurred. So, in proving the facilitation offense and the way that the indictment is framed, the prosecution is required to prove the commission of the serious offense, which forms part of the definition of the charge of facilitating whatever the offense is. So in effect, then it's prosecution are essentially proving two offenses in one. The offense facilitated and the facilitation itself. So the legal ingredients of the serious offense must have been committed, and the persons named being accused of facilitating the offense are to be looked at now as to whether they facilitated the serious offense particularized and not whether they committed crimes generally. So it means then that if it is found at the end of the day, the offense alleged to have been facilitated was not committed, then it follows that you can't facilitate an offense that didn't occur. That is the ultimate logic there. So in respect of the offense of conspiracy to murder, at the very least, the Crown must prove that there was an agreement by 2 or more persons to kill the persons named in the particulars of the count. Regarding the serious offense of murder, the Crown must prove that the deceased named in the indictment was killed or dead, and was killed by a voluntary and deliberate act which resulted in the death of the deceased. And at the time of the infliction of the injury which caused death, the person doing the inflicting must have had an intention to kill or to cause serious bodily harm and was not acting in lawful self-defense, not acting under legal provocation, and the act was not done accidentally or negligently. So that is one thing that the Crown must prove when you're alleging now that the serious offense of murder was committed by the person or facilitated by the persons named in the indictment. And I frame it in this way because the facilitation offense does not require that the person doing the facilitating was the person who actually committed the serious offense. You can facilitate the serious offense, which is an offense in its own right, and the persons or persons doing the actual serious offense may not necessarily be the same as those who are alleged to have facilitated the commission of that serious offense. Arson, reduced to its essence, is the intentional or reckless setting of fire to a dwelling house without lawful justification. Some part of the house must be burnt, and by our legislation, at the time of the setting of the fire, someone must be inside the house. And so in respect of the bodies that we had spoken about earlier, that is the male and female bodies found at the burn site of this home, the Crown is saying that this aspect of it was fulfilled because inferentially they are saying the 2 bodies that were there were in the house at the time that the fire was set to the house. The other aspect of the ingredient of the facilitation offense is that the Crown must prove that a criminal organization was in existence, because it speaks to facilitating the commission of a serious offense by a criminal organization. So the criminal organization must exist, and the organization must have committed the serious offense, and that the persons charged now for facilitated the commission of the serious offense by the criminal organization. So the criminal organization must exist at the time of the facilitation. So what is a criminal organization? The statute tells us, and just reading the parts now that are relevant for the purposes of this case, the statute tells us that a criminal organization means any gang, group, alliance, network, combination, or other arrangements among 3 or more persons, whether formally or informally affiliated or organized, or whether or not operating through one or more bodies, corporate or other associations, that has as one of its purposes the commission of one or more serious offenses. So that's what the statute says. So what does all of this mean? Well, firstly, there is no need for any formality, as in articles of association or written documentation as one would find with, for example, football clubs. The language is quite wide and encompasses what may be called even loose arrangements between persons. It's important to know that the statute does not require any permanence in the arrangement, and neither does the arrangement need to be long-term. An arrangement among 3 or more persons, because it has a numerical component to it as well, 3 or more persons for the commission of one and only one serious offense is sufficient. And the numerical component referred to it already, but to emphasize it here again, the magic number is 3. And just to digress a bit, the Crown is saying now that they are 2/3 of the way there, having regard to the 2 main witnesses for the Crown who are making the claim that they are members of a criminal organization. So the Crown is saying, well, if you have 2 persons who are making that claim, an admission against their interest and so on, all they need now is 1 more, and there you have a criminal organization, certainly as far as the numerical element of the definition is concerned. There is no need for the Crown to prove that the commission of a serious offense is a dominant purpose. There is no main purpose or dominant purpose test in our legislation as is found in other pieces of legislation across the world. All that needs to be established is that the 3 or more persons came together and you have as one of your purposes the commission of 1 or more serious offenses. It is important to note the language used within the definition of the legislation. It speaks to gang, group, alliance, network, combination, or other arrangements, whether formally or informally affiliated or organized. So it is using language to cover an almost infinite variety of ways in which persons can organize themselves. There is no one type of structure that must be found to exist, although I accept that from the definition, some kind of structure must be found to exist. But there is no one size fits all as far as criminal organizations are concerned. The words used in the statute make it clear that the structure can range from one showing a high degree of sophistication or a clear hierarchy or chain of command to one where there is a minimal degree of organization. Criminal organizations can adopt many forms, and experience has shown that depending on the environment in which they are operating, they may choose to adopt a particular method of organizing themselves to enable them to operate more easily in their particular context. So there's no one size that fits all, but certainly there must be some structure of some kind. As to what that is, there is no inevitable form that the structure must take. So that is dealing with now the criminal organization, 3 or more persons, some degree of structure, and having as one of your purposes the commission of 1 or more serious offenses. In this particular case, the Crown has sought to prove the existence of the criminal organization in this way. And before I get to this way, I should note that the statute does not restrict the type of evidence that the Crown may use to prove the case. In some cases, the prosecution may prove the existence of a criminal organization by calling persons who are expert or experts, they may be police officers, to speak to the characteristics of the criminal organization that is the subject matter of the trial. The expert witness may be able to speak to signs, symbols, dress, manner of speech, modus operandi, areas in which it operates to indicate the existence of a criminal organization. In this case, the Crown did not pursue that method of proof. I mean, it's not a criticism, it's just an observation. The Crown relied heavily on the 2 first witnesses, who, as I said they were members of the criminal organization called Klansman One Don. And essentially what the witnesses are saying and what the Crown is relying on them to say is this, that a number of serious offenses was committed. Some charged, as in indicted, and some unindicted. Crown is saying that these offenses, serious offenses, that is the conspiracy to murder, arson, were committed over a period of time by persons who are alleged to be affiliated with each other. The Crown is, by pursuing this method of proof, the Crown is relying on inferences. The Crown is saying that where you see the same group or members of the same group of persons, or persons who are affiliated with each other, who are committing serious crimes with each other over a period of time, then that fact, or those facts, if accepted, would point to the existence of and proof of the existence of and membership of the criminal organization. Because what the Crown is saying is that it is extremely unlikely in ordinary human experience that affiliated persons are going to be found committing serious offenses with each other over a significant period of time, in this case, over a 2 to 3 year period. The Crown is saying that the inference that the court is to draw is that the crimes that were committed were not the result of spontaneous, unplanned, random occurrences, but more consistent with the existence of a criminal organization or an organization that is criminal by virtue of the commission of serious offenses. Crown is suggesting that there is no organization, no structure, that if there was no organization and no structure, however loose, how is it that the persons, affiliated persons, would know when they are to turn up at different places, at different times, on different dates, and in some instances, even traveling in a convoy or in the same vehicle, if there was not a criminal organization in existence? So the Crown is asking now of the evidence that they have adduced to do double duty. That is, to establish that serious offenses were committed by persons who were affiliated with each other, and that these serious offenses were committed over such a long period of time. And the Crown is saying, when you look at all of that now, the only reasonable inference, or the inescapable inference, there is no other reasonable and rational conclusion, is that these persons must have been affiliated with each other in the context of a criminal organization. That is the argument that Crown is putting forward. Of course, the defendants are saying lies, lies, all lies, and the first witness in particular, since he was charged, what else do you expect him to do? He wants to extricate himself, and therefore, he's making up all these stories to ingratiate himself with the prosecution, and having told a lie, at least in his statement initially, to escape being tried, he really has to maintain that position throughout, because one could not realistically, the defense is suggesting, expect that the witness to just turn up in the witness box and you said, you know what? All that I told the prosecution is untrue, because that would perhaps result in him coming back into the case as a defendant and not a witness. And so the defense is saying now that he has every incentive to make up these stories. And as far as witness number 2 is concerned, the defense is emphasizing again and again that he has every reason to lie because he was never charged. And the defense is saying, surprise, surprise. And why are they saying surprise, surprise? Because here it is. This gentleman goes to the police. And according to the police, he was not, based upon their inquiries, a suspect in any crime of any kind in the relevant police area, St. Catherine North, and so on. And the defense is saying, here comes a gentleman who just simply has almost a, well, not quite, a Damascus Road experience. He seeks out the police, goes to them, confesses to, well, just about every offense short of treason. And he isn't charged with any offense. No evidence of any plea negotiations or a deal that was struck. But the decision was taken not to charge him and to use him as a witness. And so this fortunate person would do everything in his power to maintain that position, and consequently, the defense is saying he's lying through his teeth, and having started out with a lie, well, I suppose he has to maintain it in order to keep his position secure, namely being uncharged. So that is how the defense responds to this. Now, the next word that we have in the indictment now, this charge now of facilitating is the word facilitate itself. It is not defined in the statute, and an ordinary English word which really means to make easy or easier. And in the context of the criminal law, it is the act of making it easier for another person to commit a crime. So what the Crown has to prove for the facilitating offenses is that the persons named in the facilitating counts by an act or omission made it easier for persons to commit the serious offense. And as I said, the serious offense itself must have been committed. But doesn't end there. The statute uses the adverb knowingly. So that requires or imports now a mental element into the charge, where the Crown must prove that the facilitator knew of the existence of the criminal organization, did some act or omitted to do something that facilitated the commission of a serious crime by the criminal organization, and knew the serious crime or the range of serious crimes that were being facilitated, and the crime facilitated was the serious crime that the facilitator knew that he or she was facilitating, or was in the range of crimes that he or she intended to facilitate. So there's that mental element now. So at the end of the day, as far as the prosecution is concerned, it must prove that the facilitators knew of the existence of the criminal organization, that the criminal organization exists, that the criminal organization committed the serious offense, that the facilitator did some act or omitted to do something which facilitated the commission of a serious crime, of the serious crime by the criminal organization, and that the facilitator knew of the specific serious crime or range of serious crimes that was being facilitated. And the crime that was in fact facilitated was the serious crime that the defendant knew about, or within the range of crimes that he or she intended to facilitate. So that is the facilitation offenses. Then we have another offense in this indictment, which is the being part of a criminal organization. That's count 2. And part, well, of a criminal organization simply means that the person was a member of the criminal organization, and the statute does not use any word such as knowingly, being a member, but I would want to think that there is a mental element, at the very least, knowing that the organization is a criminal organization. So that to be an indication that you knew of the criminal organization and that you voluntarily became a part of it, knowing that it was an organization that had as one of its purposes the commission of one or more serious crime. Now, being a member doesn't necessarily mean that you have to actually commit a serious offense. I mean, you can simply be a subscribing member to the organization, agree with its aims and objectives and mode of operation and the things that it does, but you may not have the constitution or the fortitude to actually do it yourself. But you can still be a member in that way. But in any event, what the Crown is saying now is that the evidence that proves the existence of the criminal organization. It's the same evidence, it's triple duty now, the same evidence that is going to prove membership of the criminal organization. So the Crown seems to be saying, well, look, here you have these persons, A, B, C, D, and E. Over a period of time, they turn up at point A, point B, point C, commit serious offenses. They do this consistently, persistently. And the Crown is asking the court to infer now that these persons must have been members of the organization, or else, how else do you explain them turning up at the appointed day, at the appointed time, committing serious crime repeatedly over a 2 to 3 year period? So no membership list has been produced, not surprising here. So criminal organizations may not necessarily want to document their activities. Indeed, the first witness for the Crown indicated that he was the banker and chief accountant. And when he got wind that some state of emergency would have been called in Spanish Town, he ensured that he destroyed all records, financial records that may fall into the wrong hands. From the criminal organization standpoint, wrong hands meaning the police. And that may provide them with information. So thereafter, I suppose they would have to rely on their memories and other forms of record keeping. So there's no membership list as far as this case is concerned. But what the Crown is saying now is that they're asking the court to infer that the persons who did the serious offenses in the manner indicated by the Crown must have been members of the organization. So that is what the Crown is saying in terms of its method of proof. As far as the leadership of the organization is concerned, that's one count on the indictment, and that is in respect of the defendant, Mr. Andre Bryan, and he's charged with leading, well, between the specified dates, led a criminal organization, namely the Klansman Gang, One Done Gang. Again, leadership is not defined in the statutes. So you go to the you go to the statute and you look to the dictionary meaning. So the three words in the statute, section 7.1a, speak to leading, managing, directing. Now these words are not synonyms, but it is clearly that there's a degree of overlap. And so what the statute is getting at is seeking to criminalize persons who may not necessarily be on the ground when the serious crimes were being committed, but who would give strategic direction, guiding, influencing the activities of the criminal organization. And so where that kind of behavior is identified and that person is being presented in the evidence as an authority figure and a person whose blessing has to be given for certain activities to take place and who is consulted from time to time or seen to be giving directions to the other members of the organization, then the Crown is saying that all of that points to the person being the leader of the organization. And the Crown is suggesting that in this particular case, there were persistent or consistent references to persons referring to or deferring to Mr. Bryan. And the Crown is not only relying on the say-so of the two witnesses, but the Crown seems to be relying also on telephone recordings in which witness number 2 is alleged to have recorded conversations between himself and other members of the gang. This was in real time now. Other members of the gang, and the way in which they spoke about Mr. Bryan, the Crown is saying, showed at the very least as between the speakers that they regarded Mr. Bryan as the leader of the organization. Now, let me say clearly that there was a testimony from one of the police officers that Mr. Bryan was being questioned in relation to some incidents that were taking place in Spanish Town. And in the view of the police, Mr. Bryan was a person of influence who may be able to, or may have been able to assist in the reduction of those incidents in the Spanish Town police area, St. Catherine North. That evidence can't be utilized to determine whether Mr. Bryan is leader of the organization because, well, there was really no foundation for that belief. All it means that the police may have had that view, but you have to present the material now upon which you are relying to form that view to see whether there's any substance to it. So as far as I'm concerned, at this stage, it was at best a belief that they had, which may or may not have had any basis in reality. But what the Crown is saying, though, nonetheless, is that when you have these two witnesses, plus the telephone calls and so on now, then the cumulative effect of that is to show that Mr. Bryan was the leader of this organization, being the ultimate authority figure, had the ability to override and make critical, strategic, and operational decisions. And so all of that, the prosecution says, points or point to him being the leader. And just before we come to this the end of this first phase of the summation, because of the manner in which the Crown sought to prove the existence of a criminal organization, the members of the criminal organization, the court has to be mindful of this principle. And that arises from the case of Makin and the Attorney General, which essentially says you don't adduce, or it is impermissible to adduce evidence of bad character and then turn around and say because he's of bad character, he must have committed the crime. Evidence of unindicted offenses can be adduced provided it is relevant to an issue in the case. And what the Crown seems to be suggesting is that in this particular case, one of the critical issues was the existence of a criminal organization. And they sought to prove the existence of the criminal organization by the commission of serious offenses by persons who they claim are affiliated, and that these offenses were committed over a period of time. And inferentially, that could not have happened in the absence of the existence of a criminal organization, one, and two, the persons who are affiliated with each other committing these crimes being members of that criminal organization. So in looking at the evidence, the court has to be careful that it is not a case of adducing evidence of unindicted conduct and then turn around and say, oh, if you did these, then you must have done this as well. So that, I believe, takes us up to the break in this case. So we'll be adjourning for half an hour, then return at 10 minutes to 12 to continue. Oh, we're there. Oh, I see. So, okay, we'll return at 2 o'clock then.
Stand, please. This record is now adjourned until 2 p.m. God save the King.